Hello and welcome to Eye to Eye. I'm Russ Mitchell. Katie's off today. In the wake of the storm surrounding the firing of 8 U.S. attorneys, a former Justice Department prosecutor is raising another charge of political interference from the Bush administration. Sharon Eubanks tells Bob Schieffer that in a multi-billion-dollar lawsuit, she was asked to go easy on big tobacco.
They actually drafted for me a position to take on a smoking cessation remedy, which would reduce what the government had been seeking in the case from $130 billion to $10 billion without any explanation.
Well, now wait a minute. Let's go back here. Your supervisors tried to get you to change the testimony that your witnesses, these were what, expert witnesses, were about to get?
Expert witnesses and at least one fact witness. With an expert witness, I can understand if you are a proponent of a particular view, you ask them to focus on that view. But one of the witnesses was a fact witness, and they asked me to approach him about changing his testimony, and I said, that's wrong. I'll tell him what you said.
They wanted you to tell him to change his story?
Yes, and this is a little bit unusual. The judge had a process or procedure in place where we had written direct testimony. So my supervisors at the department, all political appointees, demanded, as it became clear that we were close to victory in the case, that they see, before I file that testimony, that they have the opportunity to review it. And upon reviewing some of that testimony, they demanded that changes be made.
Well, what did they want him to say?
Well, it was more what they didn't want them to say. And one of the witnesses that I approached with it said no. The fact witness, I explained to him what was being requested and where the request was coming from, and I asked him for his position on it because I felt ethically I could do no more than that. I was in a difficult position. The supervisors are saying, do this, and I'm telling them, if I do this, he's not with the government. He can speak out about it, and he did. This was Matt Myers. And the political people are saying, you have to do it. And when Matt Myers said, this is my testimony, and I don't feel comfortable with that, it's as I stated it on the written record. He wouldn't change his testimony.
Well, what did they want him to say? I mean, what was he prepared to say, and what did they want him to say?
Well, they wanted him to say less about some of the remedies that he felt were appropriate regarding issues that the administration claimed would invoke First Amendment concerns that they had. I said, well, we can sort that out in the briefing. This is just what the witness is saying. He's a fact witness. We don't have to urge it if we don't believe that it's appropriate under the law. But if this witness has said that as a matter of fact, this is something that we considered in the past with these companies, I don't see the problem.
Now, Ms. Eubanks, did you get the feeling at the time that your superiors, who were all political appointees, were ordering you to make these changes because they wanted you to go easy on the tobacco companies?
Yeah, and if we could just call them supervisors rather than superiors, I'd be more comfortable
All right.
with it. But yeah, they did want me to weaken our positions because we had been going along just fine on the case for quite some time, pursuing it bit by bit, piece by piece. I had something like 35 lawyers on my staff, and the industry had hundreds of lawyers. I think that it was surprising to the administration officials that we had done as much as we did. And then one day in a meeting with them, as it got close to the end, I sat in a room with Robert McCallum and Peter Keisler and Dan Marin, all political appointees, and I said, gentlemen, I'm going to tell you something I've never told you before. We're winning this case. We have as good as won. Here's what remains to be done, and it can't touch what we've got in the way of evidence. Real trouble began.
Well, what was the trouble? Then you got these calls. You told the Washington Post that they actually dictated your closing argument.
They drafted it. They told me to say it, and I read it verbatim. Changes were made as late as the morning of the argument. I received a phone call from Peter Keisler when I was in the taxi on the way to the courthouse asking me to make a pen and ink change to the document that he, McCallum, and Dan Marin had put together the night before and had emailed to me. And I made that change to the document. And then when it was time to provide that information to the judge at closing, I went to the podium, Bob, and I read it. I couldn't look up.
You couldn't look up?
I couldn't look at the judge and say that. For 9 months, I had seriously and vigorously prosecuted this case. And now I've got to cut it off at the knees myself. I couldn't look at her.
Did you argue with them when they told you to do this?
Oh, yes. I argued with them. My deputy argued with them. Members of my staff argued with them. And you thought you were having, in the beginning, a productive argument, like in the old days in the Justice Department. And someone else comes in with their position, you air it, and maybe there's some movement on either side, and at the end of the day, you're told this is what we're going to do. Well, this was strange. For the longest time, they wouldn't tell us this is the number we want. They just kept saying it should be lower. I think they wanted to have deniability on them dictating the number. But finally, when things became so heated, I felt I had to protect my staff, and I stood up and I said, you write it and I will read it. Just do it. And that was a very difficult and painful moment, but had to be done.
Now, when you retired from the Justice Department shortly after this case was done, you said at the time that you felt you were not getting support from the supervisors at the Justice Department, the political appointees, but you didn't say very much else. Mm-hmm. Why now are you coming forward?
Well, a couple of reasons. At the time when I left the department, there were constraints on privilege and what could be said and what could not be said. But subsequent to my leaving, Robert McCallum was nominated to become the ambassador to Australia. And in testimony on the Hill, he was asked questions about what happened at the end, and he gave his spin, if you will, on those facts. So there was no privilege if the person at the Justice Department was waiving it. That's one issue. The other really important issue at this point in time is that this case is on appeal. And the same people are in the Justice Department, the same, Alberto Gonzalez, Peter Keisler, those people are still there in a decision-making position to determine what the United States will do and what it will pursue on appeal. They're still there. If we look away from this, then it will never be remedied.